If you ever thought, if I get sued, I will just move everything into my spouse's name, stop. That one move can take a bad situation and turn it into a disaster, especially if you don't have a spouse. Because in California, when you move money or property at the wrong time or in the wrong way, a creditor can challenge it as a voidable transfer, and the court can unwind it. Not in theory, in real life. In this video, I'm going to walk you through the 5 mistakes that blow up more asset protection plans than anything else, and exactly what the law says about each one. But stay with me until the end, because I'm going to share something that most attorneys will never tell you, a different way of thinking about voidable transfers that changes how you evaluate your entire plan. It is the most practical insight I can give you about how asset protection actually works in the real world. And it is the part of the video that I think will stick with you the longest. I'm Talai, a California asset protection and estate planning attorney and founder of Talai Law Offices. My practice focuses on protecting what real estate investors and high net worth families have spent a lifetime to build. Before we get into it, if you want to see how I structure full asset protection plans here in California, including LLC strategies, holding entities, Wyoming holding entities, trust, irrevocable trust, and layered protection, I walk through all of that in my free asset protection webinar. Registration link is below. And if you go to my Instagram and DM me the word webinar, I will send you the link directly right now. First, a quick note on terminology. Most people still say fraudulent transfer. California adopted the Uniform Avoidable Transactions Act, the UVTA, and the correct modern term is voidable transfer. Same concept, updated law, and the distinction matters because the framework is more precise than the old fraudulent transfer label implies. The UVTA is founded in California Civil Code section 3439 through 3439.14. It gives creditors tools to challenge transfers that were made to hinder, delay, or defraud them, and transfer is broader than most people realize. It includes signing over real estate, gifting cash, moving business interests, paying money, and creating liens in certain contexts. The law has 2 main theories. The first is actual intent. The creditor claims you transfer something with the intent to hinder, delay, or defraud them. The second is something called constructive voidability, where intent is not the issue. The question is whether you received reasonably equivalent value for what you transferred and whether you were financially strained or insolvent at the time. Some claims can be brought even if the creditor's claim arose after the transfer, depending on the theory. If a transfer is successfully challenged, the court can unwind it, order attachment, issue injunction to stop further transfer, or even appoint a receiver. The law allows recovery from the transferees in certain circumstances with limits depending on good faith and value received. All right, so let's talk about the 5 mistakes that blow up asset protection plans. Mistake number 1, moving assets after a lawsuit is filed or when litigation is clearly coming. You get served or you get a demand letter or a business deal is unraveling and you know litigation is on the way. Suddenly, you feel kind, and now you want to transfer your home to your spouse or move your savings to a relative or shift company ownership to a friend. Even if you call it planning, courts look at timing under the UVTA. One of the specific factors court consider is whether you had been sued or threatened with the suit before the transfer. That is a classic badge of actual intent. Timing does not automatically end the case for you, but it is a significant red flag that makes the transfer much easier to attack and much harder to defend. Mistake number 2, transferring property for less than fair market value. This is the sell it for $1 mistake, or give it to my kids, or transfer it to a cousin and call it a sale. Under California law, a transfer can be challenged if you did not receive reasonably equivalent value. especially if you were insolvent at the time or you became insolvent because of the transfer. The law does not require proof of conspiracy. If the math and the timing lines up, the transfer becomes a problem. Let's talk about mistake number 3, using sloppy entities or fake paperwork to hide the transfer. This is not an argument against LLCs or trusts. Real structures built for real reasons are some of the most effective asset protection tools available. The mistake is treating an entity like an invisibility cloak, forming an LLC with no real operations, no separate bank accounts, no clean records, then transferring an asset into it while continuing to use it exactly as you were doing before. Or backdating documents or creating paperwork that does not match what actually happened. Courts look at substance over labels. Under the UVTA, courts can consider whether the transfer was concealed, whether it was to an insider, whether you kept possession and control after you transferred it. If the entity is just a costume and you still control everything, you are stacking the odds against yourself and turning a manageable situation into a much worse one. Let's talk about mistake number 4, assuming time will make it disappear. Many people believe that if they transferred something years ago and have not been sued yet, the window has closed. Not necessarily. California Civil Code 3439.09 sets out the time limits, and they are not as short as most people assume. For actual intent claims, an action must generally be brought within 4 years of the transfer or within 1 year after the transfer was or reasonably could have been discovered, whichever is later. There's also a 7-year outside cap. The point is simple. A transfer can come back to haunt you years down the road. All right, let's talk about mistake number 5, the last mistake. Assuming transfers to family are automatically safe. This is probably the most common misconception I see. People think it is their spouse, so it is fine, or it is their child, so no one can touch it. However, transfers to insiders are actually scrutinized more, not less, because it is easier to pass assets to someone close while still keeping control behind the scene. The UVTA specifically lists transfers to insiders, retention of control, and concealment as factors courts consider when evaluating actual intent. If you transfer asset to a family member and still manage the account, still live in the house, still treat the asset as yours, you're handing a creditor a checklist of red flags. All right, so now you might be thinking, how and what a smart, legitimate asset protection actually looks like? The correct answer is boring, and that is exactly why it works. You plan early, you document everything, and you structure ownership for legitimate business and family reasons, not a last-minute reaction to a legal threat. The mindset shift is the strongest asset protection is built when there is no creditor problem on the horizon. Once there's smoke, every move gets interpreted through the lens of the intent and fairness. Early planning creates maximum friction with minimum risks. That is the combination you would want. That means if you sell something, you sell it for real value. If you use an LLC, you treat it like a real company. Separate finances, clean records, legitimate operations. If you use a trust, it has a real purpose and it is done correctly, and you avoid secrecy. If you ever find yourself thinking, I hope they do not notice this, you're already in danger territory. The law also has defenses. The UVTA protects transferees who take in good faith and for reasonably equivalent value. That is another reason arm's length transactions and proper documentations matter. They protect not just you, but they protect the people you transfer the property to. And if you are already being sued or already have a judgment against you, do not start moving assets around based on something you read online. Your options at that stage may include negotiating, evaluating exemptions, and handling the case strategically. But panic transferring assets create a second legal fight on top of the first one. That is when you need a real attorney evaluating your specific facts fast. And I want to be honest with you about how asset protection actually works in practice, because it is different from how most people think about it. Most people assume the goal of asset protection is to make assets completely unreachable, that if a creditor can challenge something, the plan has failed. That is not how experienced asset protection attorneys think about it. And it is not how I think about it either. The real goal of asset protection is friction. When a creditor wins a judgment, they do not automatically get paid. They have to collect, and collection costs money, takes time, and carries uncertainty. A creditor looking at a properly structured plan, LLCs with charging order protection, layered entities, trust with the right provisions, has to ask, is pursuing this judgment aggressively worth it, or is a negotiated settlement the smart move? That calculation changes everything. I have seen creditors with valid judgment settle for a fraction of what they were owed, not because the plan was impenetrable, but because the cost and complexity of collection made a lower number more attractive than years of litigation. And here's the honest truth about last-minute planning. Even a transfer that might be challenged as voidable is not automatically worthless. If a creditor has to file a separate voidable transfer action, spend legal fees, wait for an outcome, and still face uncertainty about recovery, that is friction. That is leverage for settlement. That is a reason a creditor might accept less than a full judgment just to make the problem go away. Now, I'm not saying you should make voidable transfers. What I am saying is that in the real world, the presence of any legitimate planning, even imperfect planning, changes the dynamic of how a case resolves. And that is exactly why the 5 mistakes I walked you through matter so much, because those mistakes do not just create legal exposures, they destroy the friction. A sloppy entity, a backdated document, a transfer with no real value exchange, those give the creditor the ammunition to unwind everything. Suddenly, there is no structure, no complexity, no reason to settle. The friction is gone. The strongest asset protection creates maximum friction with minimum legal risks. That means planning early, building real structure, and doing it the right way before a creditor is on the horizon. Because early planning does not carry the voidability problem. It just creates the friction cleanly, legally, and permanently. That is the combination you want. And that is what a properly built plan delivers. Key takeaway. The 5 mistakes are real, but the goal was never perfection. Moving assets after litigation is threatened, transferring for less than real value, hiding behind sloppy entities, assuming time protects you, believing family transfers are untouchable. Those mistakes turn a manageable situation into a disaster. Avoid them. But the deeper lesson is this: asset protection is not about building a wall that no one can ever touch. It's about making collection difficult enough that a rational creditor chooses negotiations over litigation. The goal is leverage, and leverage comes from planning early, building real structures, and doing it correctly before the threat arrives. Plan early, build real structure. The goal is not perfection. The goal is leverage. If you want to go deeper on how to build that kind of protection the right way, do not miss my next video, How the Ultra-Rich Protect Their Homes, California Homestead Exemption Explained. That one covers the strategies you can use legally and effectively without stepping into the voidable transfer trap. I will look forward to seeing you over there.